Good morning.
Good morning. If it pleases the Court, Stephen Maidman for Defendant Ishmael Vasquez. This is a multi-defendant case, and the main issue from Defendant Ishmael Vasquez's point of view is the severance issue, and in particular whether there was compelling prejudice such that it was an abuse of discretion for the judge not to grant severance, and more importantly, for the purpose of the appeal, whether there was whether the Commonwealth's two contract witnesses, Shorty and Shine, and I'll use the names that you'll see in the transcript for the purposes of this, because otherwise it's very difficult to keep track of it within the transcript. But whether the Commonwealth's two cooperating witnesses constituted independent witnesses for the purposes of the Moran case. I think the evidence in the record is very clear that there was compelling prejudice. We had originally you had 5 defendants, at least 3 or 4 of which were asserting antagonistic defenses, irreconcilable defenses, within the legal definition of antagonistic defenses. You had, from Ishmael Vasquez's point of view, you had him saying that Shorty, Shine, and Davenport independently were the perpetrators of the crime, and then you had Davenport saying that he was forced to do it by my client, by Ishmael Vasquez. And prior to their plea deals, you had Shorty and Shine saying, asserting antagonistic defenses as well in pretrial papers. So there's no, I don't think there's any.
Who did they say did it? Who did they say did it?
They say that they were ordered to do it by my client Ishmael Vasquez. So there's the case there's a line of cases which say that if there are independent witnesses, it doesn't matter whether the prejudice is compelling or not. But each of those cases involve witnesses who were non-party witnesses. They were bystanders, bartenders, and the cases are in my brief. They're in the Commonwealth's brief, and it's pretty clear that these are not people who were former co-defendants as recently as the last business day before the trial, or in the case of Shorty's case, 18 days before the beginning of the trial.
So explain to me why that makes a difference. That these folks had been charged, agreed to plead guilty, and were now testifying, so they were not on trial.
Well, they were under the control of the Commonwealth. They were not independent. They had plea agreements, and they were executory. They really were executory contracts.
So you mean independent evidence? You mean evidence that's not somehow under the control of the Commonwealth?
That's not subject to a plea deal. At least within the cases. The cases involve bartenders, people who clearly were witnesses, and in this particular situation, what you have is you have people who were co-defendants up until shortly, literally the last day before the trial, last business day before the trial. They were co-defendants, and now all of a sudden they get reincarnated as independent witnesses. These people were not independent. And the jury was carefully instructed that they had cooperation agreements.
What's the rationale for saying that even if there are irreconcilable defenses, if there are independent witnesses, that there's not going to be the kind of compelling prejudice? What's the rationale behind that? I mean, you're stressing they're not independent. What difference does that make?
Well, the rationale, at least according to the Moran case, is that the jury could disbelieve any of the co-defendants, and they could choose to believe the independent witnesses. At least that's what the case says.
Okay.
This is not a well-developed area of Massachusetts law. I mean, there's not 100 cases on this that I've been able to locate anyway. Mm-hmm. I mean, there's the cases that are in both the government's brief and in my brief and Luis Vasquez's brief. So there's not a lot. I mean, I wish I had a better explanation. So I went. In matter of fact, in my brief, I cited Black's Law Dictionary. What does independent mean? Actually, I think Mr. Luis Vasquez said that. Or both of us did it. The bottom line is that in terms of independence, like independent experts. I mean, why is an expert independent?
Well, but, okay, so you're saying somebody, just a purely precipient witness who has no stake
Right.
in the outcome?
Right. I think that I agree with that. These were not purely precipient witnesses. These were biased witnesses. If these people at the trial, taking the defense point of view, did not perform appropriately for the Commonwealth could have walked into court and argued that they're not entitled to the agreed sentence under contract theory.
I'm betting that these women were cross-examined about the plea agreements.
They were cross-examined for days.
Yeah, and
Literally days.
Right.
You really, this is to the extent that this court can discern. This was one of the longest murder trials in the history of Suffolk County. It may be the longest. The transcript goes on for literally thousands of pages, and to get a flavor of this, one need only read the cross-examined by Attorney Elliot Weinstein of Shorty and Shine, in other words, Mr. Vasquez's lawyer. The jury clearly knew that these people were biased. But again, the real issue is, was this a fair trial, and did it violate due process? By having, and in my brief, I go on for a massive footnote detailing all of the various examples of the prejudice. And let me just, aside from Shorty and Shine, Davenport. I mean, one of the problems is that there were so many motions for severance that it's hard to keep track of them. Okay, there were pretrial, and Judge Brady made a good point. He said it's very fact specific. Okay, we need to have a trial. But once the trial began, it was so. I think it's a fair reading of the record that it was very clear that there was prejudice, and I would suggest compelling prejudice, overwhelming prejudice. You had, for example, you had Mr. Davenport's lawyer acting as a second prosecutor. And every single thing that he could have done to frustrate the defendant Ishmael Vasquez and the non-Davenport defendants was done. And then he gives a closing argument on basically a duress defense, saying that that defendant Ishmael Vasquez ordered him to do it.
Let me ask you now, Ishmael and Luis are brothers?
Yes, or half-brothers.
Or half-brothers. Is the claim that they had mutually antagonistic?
That was never, I don't believe that was the posture at trial.
Okay.
I don't think that's the claim.
Okay.
And there's another one, a third one, Harold Parker, better known as Trini. Okay, there were three
Parker wasn't tried?
He was tried. He's not part of this appeal.
Okay.
Okay, he's not part of the appeal for procedural reasons.
Okay. He was also found guilty?
Oh yes, everyone was found guilty. In a 7-week trial, it took the jurors about less than a day. But returning to Davenport's counsel, he gives a closing argument, and it's quoted in my brief, that could have been given by the Commonwealth. And the truly extraordinary thing about it is that he gave a closing argument arguing duress after Judge Brady precluded it as a defense. So I want to move on very briefly to the juror issue, but again, I would suggest that the independent witnesses were not truly independent, that prejudice was compelling, and it rose to the level of a due process violation under the 5th, 6th, and 14th Amendment. In my remaining minute, let me just briefly say something about the juror issue. And the point I want to make about the juror issue is that this is an important issue for policy reasons. And the reason it's important is that the Commonwealth came back and not only argued, they challenged the juror, they came back and exercised a peremptory challenge. Consider the situation where a defense lawyer in the future comes forward and says, Judge, I would like the opportunity to do a little investigation. After I passed on all these jurors, I would like to reserve an entitlement to exercise a challenge. After I passed. Not for cause, but a peremptory challenge. It would seem to me that no judge would go along with that, and that's exactly what happened in this case. That's what the Commonwealth did.
This wasn't addressed in Hampton or in... Not
like this. Hampton talked about reserving an entitlement. It doesn't go into... Hampton does not talk... I'm not sure any of the cases talk about peremptory versus challenges for cause. And I would also say one of the cases cited in my brief is the Harbin case. It's a Federal Circuit Court of Appeals case. In that particular situation, there was a saved peremptory challenge that was exercised mid-trial. But the rationales that are discussed in there are equally relevant to this Court. And unless the Court has any further questions.
Thank you, sir.
Thank you.
May it please the Court, David Lewis for Louis Vasquez. I just want to point out for the record as well that members of Mr. Vasquez's family are here in support of him. Sort of start at the end and sort of move through the question about wasn't this covered by Cousin and Hampton? Hampton actually talks about whether or not the allowance of the Corey after the jury was sworn was the issue. Here, it seems to me, you're talking about sort of the reverse of Susie, or however that's pronounced, where there was an erroneous denial of the right for a peremptory challenge. I think here you're talking the erroneous allowance of a peremptory challenge after the jury is sworn. So I think it's just a little bit different. It gets sort of wrapped up, and it was by us as well, with Cousin and Hampton. But actually, in going over the materials, I think it's just a little bit different. I think you're more talking about I think when he boils it down, the crux of the issue is really forfeiture. And how is a forfeiture by the Commonwealth dealt with? And what standards apply to that? And, waiver, express relinquishment of a known right or abandonment of that right, not probably really. I would concede that. There's no express. They said expressed contentment, and it moved on, and jury was sworn, and everything procedurally went on. But I think pretty plainly there was forfeiture. They had an opportunity to say something. We're going to express contentment, but we're still checking. It's going to take us this afternoon. We'll get back to everyone tomorrow morning, first thing tomorrow morning, like the procedure Hampton talked about doing. But they didn't say anything. They just said, like everyone else, we're content. We're going to move on, and that's where it went from there. So I think it's a little bit different from those cases, and I think that's, to me at least, I think that's sort of the crux. And I think they had an obligation to say something. And I think the not saying something, I think the single justice, there's a comment in his order, sort of the top of the second page, and I think there's a mistake of fact actually saying, he says there was no way they could have done this ahead of time. That's actually not true. They could have if they'd wanted to. It would have taken some time, and it would have taken some effort, but it is possible. They could have done it. And you're only talking about 4 jurors. It wouldn't have taken that long either. So I think that issue really turns on their failure to say that their contentment with the jury was contingent on them continuing to investigate. Very quickly would turn to the severance issue as well, and just would draw a quick distinction and then sort of make my own comments about my client's position. My client was the only one to present an affirmative defense in this case. And when I was doing the research for the brief, and as is in there, and I'm not going to regurgitate that, the cases where you're talking about 2 co-defendants and one is presenting duress and the other is presenting a defense that they were not present at the scene, that those are mutually antagonistic. And because if you believe duress, you obviously can't believe that he was not there. And vice versa. If you believe that he was not there, part of that duress defense completely falls away, just by a matter of logic.
Wasn't, though, Davenport, at least I thought from prior counsel, wasn't Davenport saying that it was Ismail who forced him to do this?
My recollection of the record is he said they were all forcing him to do it.
They're all, including Parker and everybody was
Correct.
forcing him.
He said the 3 of them, basically, which gets into the Bruton issue that I'll touch on in a second if there's sufficient time. But my recollection of Davenport's statement to the police, and that was partially read by, I think it's Officer Flaherty, but I'm not sure positive that's correct. And then by Davenport's testimony is he was afraid of all of them and that they all put him under duress. And it's only when you get beyond that, and this is part of it, just the clarification, in my understanding of it, is it's only once you find that you get to the independent witness issue that removes whatever prejudice was created by that mutual antagonism.
But what if we were to say that we don't recognize duress as a defense?
I think that argument is made to the jury as well. I mean, I think the operative fact from my client's point of view is that it eviscerates his defense. It just goes away. I mean, there's nothing there anymore. He has no opportunity to get a fair trial with a co-defendant testifying that says, he put me under duress. I did it because he made me. When my client is presenting evidence that he wasn't there. He joined the group later. He was not there for any of that to happen, and this guy is just saying that.
Did anyone else besides Davenport say that he was there, that your client was there?
That's where we get into the independent witness issue, is that
What about Ismail? Didn't he say?
He didn't testify.
Didn't testify, okay.
Right.
So the only people who would have, Davenport testified and...
Anna White and Lorna Lean, who were the
Okay.
two other women.
Okay.
And that's where you get outside. My reading of those cases, and they're all in my brief, there's about 6 of them. There aren't really that many that I was able to find. My interpretation of them is what you were looking for is to get someone out of that sort of co-defendant bubble, if you will, or outside that circle that can say X, Y, or Z, and that isn't obligated or behooven to the Commonwealth or anyone else to say any particular version of the story. And if you don't have the independent evidence, I mean, the cases I looked at, and again, this is in the brief and the reply, I did not find a case in the Commonwealth, or anywhere else for that matter, where a co-defendant was considered an independent witness under these circumstances.
Did Edward Assad, Chaos, say anything about who was there at the time?
Chaos's testimony, he wasn't there at that particular time.
No, but he was
Yeah.
there, one of the people who got...
He was there when they get picked up in the car.
kidnapped. Right.
He was there when they get picked up in the car and later. There were no charges of kidnapping for that incident. Those were all null prosecuted, I think, in the Cambridge District Court. They were originally charged with that, and then later on that went away. The kidnapping wasn't for the victim. That was that. The kidnapping related to the victim, not Edward Assad.
But he testified?
Correct. But it was later. It was those events are after the
Much
murder
later.
and yes.
How much later?
I don't know. I mean, they suppose the testimony
Days later?
was back to the car. I think Anna White, Laura Lean, and Davenport
In the
testified.
same time frame, but you're not talking about days later.
No, like hour,
Just
2
that?
hours.
Okay.
I mean, you know,
Right, all right.
later that evening. Yes. So, and the issue I sort of alluded to before, when it was mentioned about other people placing him there, that sort of gets into the other issues, 2 of the other issues I raised in my brief about the Bruton issue with Harold Parker's statement that was read into the record that referred to other people made him or threatened to kill him if he didn't go along. And the Commonwealth's brief talks about, well, Davenport was there and these 2 other women were there too. And that's just not, it's just fallacious. I mean, the reference was to Ishmael and my client.
Didn't you say that the judge said something about this?
Yes, I don't, it's the citation's in my brief. I don't remember it off the top of my head.
But that he recognized this as referring to specifically your client?
My recollection, I think the objection was either from Ishmael's lawyer or my client's lawyer at trial, and they said, well, clearly, we object to this coming in. They're clearly referring to other people are clearly our clients. And the judge said, I know, but I don't think it's a Bruton error, so it's coming in denied. That's my recollection of what happened at the sidebar. So that sort of adds prejudice to my client about whether or not his defense of not being present.
When you said, if I understood you correctly, your client was the only one who raised an affirmative defense.
Correct.
I'm just trying to flesh this out a little bit.
Sure.
Did he give an alibi notice?
I don't recall.
Okay.
There was no. I don't recall.
I understand that doesn't necessarily mean.
Right.
But I'm wondering if he was saying he was 10 miles away at the time.
He was. Well, the testimony was from his fiancée, who testified that he was home that evening, received a phone call, then received another phone call right after that, and then he left.
Yeah.
And then he called later that night and said, "I'm in Cambridge Police Department." I don't recall if there was a notice of that to the Commonwealth. I also don't recall the Commonwealth ever saying they felt prejudiced that this is popping up out of nowhere. The one comment I would point out, because obviously this is a voluminous transcript, that I neglected to mention when we were talking about severance and how the judge even looked at the case. And sort of later on in the case, I believe it was Ismail's lawyer, made a comment, said, and they were sort of cleaning up and doing housekeeping, and said, I want to make sure objections apply to all of us. And the judge's response was, I have treated them as coming from any of you three. Davenport's different. And to me, at least, that was indicative of other instances throughout this trial where Davenport was always different. And it was duress. And that was, it never explicitly said that, but I think when he affirmatively raised it or said it, the judge said, well, yeah, I figured this is where this was going to go. So it wasn't like it popped up late. Everyone sort of knew this was there. He just didn't disclose the defense early on, officially.
Did he raise it in the motion for severance? Or at the hearing on the question of severance?
Davenport.
Yeah.
My recollection is the severance motions, Davenport never joined those until much later, or he had his own grounds for raising those later, and I can't recall the grounds for them. But throughout that the movers for severance were the other three, and then, you know, my client has slightly different defenses than they did, or does have different defenses than they do. And it was only later, after he had testified, and I think it was around the rebuttal evidence that came in from the Commonwealth as to Davenport, I think that's when Davenport started to say, I request severance, or I request a mistrial. And that's when he started speaking up and sort of agitating for a different relief from the trial judge. But previous to that, he hadn't said anything.
Mr. Lewis, your time is up.
Thank you very much. Ryan, my brief.
Good morning, Your Honors. Kevin Nixon for Scott Davenport. Mr. Davenport's appeal raises a single claim of error, the judge's handling of duress. And at trial, this issue, as you can see from the record, was well preserved after being presented very well by Mr. Davenport's testimony. And as you know, Your Honors, duress is a defense in criminal cases. And whether duress, though, is a defense in a murder case involving the intentional killing of an innocent person, as we have here, is still an open question in Massachusetts. It's been discussed in the felony murder context in a couple of cases that were decided more than 20 years ago, but it's the first time that it's on all fours here for this court's decision. And I think, you know, the infrequency of this sort of claim is demonstrated in large part by that fact. Here we have the appellate court that's been sitting longer than any other continuously in the Western Hemisphere, and it's here for the first time. So the judge ruled following common law.
It's not here for the first time in other jurisdictions, which have pretty consistently rejected it, even though
Yes.
the model penal code suggests it's an appropriate defense.
Yes, Your Honor, and that was the authority that the judge at trial relied on. The majority of states, the ones that don't adhere to the model penal code, I think those are 8 that follow the MPC, continue to follow the common law rule that appeared a long time ago, which is that duress is not a defense when it involves this sort of killing. And so the question for the court is whether that should be followed here, and I suggest that it should not. There really are only a couple of justifications for this rule, and I suggest that neither one of them holds sufficient water to continue to follow it at this date. One would be the moral justification, and that's rooted in the idea that all innocent lives are equal in value, and that the killing of an innocent person by another innocent person, in this case Mr. Davenport, is never justified. But it's the no justification rationale doesn't mean that there's never an excuse. For instance, insane persons aren't justified in taking an innocent person's life. However, under the law, they are excused. The other thing so Mr. Davenport at trial was asking the judge to give an instruction that would make duress an excuse to that extent.
So why didn't he kill the guy who told him to kill the victim?
He explains at trial, Your Honor, the terror that he was experiencing with 3 men armed behind him and 2 women who he didn't know holding down the woman in front of him. He was on the BU, not on the BU highway bridge, but on the BU rail bridge. He couldn't see what was beneath him. There was a bright light that was in effect blinding him as he stood there. He had never been there before. The only thing underfoot were the railroad ties. He felt, and he was suffering the effects of the heroin he had injected only an hour earlier. He didn't know these people and could not believe that he was in that position. The judge, in fact, said that if he felt he could instruct on duress as a defense to murder, the evidence certainly would support that defense.
Was there any evidence that the other people had weapons?
Oh, yes, yes. Luis was carrying a set of nunchucks that he used on the skull of the victim. The other 2 men, Mr. Parker and Ishmael, were both carrying knives that they seemed to be experienced in handling. Mr. Davenport was given a knife. It was slapped flat on his chest with these men holding knives at him, telling him, "You're going to do it, or you're not getting out of here." Now, the other
He couldn't flee?
he could not flee. They were behind him.
What was in front of him?
The 2 women.
And what was after them?
The ties beneath his feet. He felt like there was no way he could run in that environment. And he would have had to first get past the 2 women who were holding down the victim.
I mean,
I think the Commonwealth suggests he could have jumped into the water if he could
These
see
are
that.
that's the problem here. Mr. Davenport wasn't asking for a directed verdict in his favor. He was asking that this case be decided by the jury. These sort of fact-specific, fact-intensive inquiries that you're raising, Your Honor, are perfect for a jury. Those are the things that belong with a jury, not being decided by the judge's ruling that there's an absolute bar to this sort of defense for Mr. Davenport.
May I ask you, is there any other state that allows duress as a defense?
Yes, Your Honor. There are 8 states that follow the model penal code. They're collected in the brief. There are additionally 3 states that allow duress to mitigate murder down to from first degree to second degree, from second degree to manslaughter. That was another request made by Mr. Davenport at trial. And let me talk about mitigation for a minute, Your
but
Honor.
how many states have rejected duress as a defense?
I think the other ones have for the most part actually considered it and rejected it. That would be the other 42, Your Honor. Although there's some subset of that is like this state in that they've never had to actually look at it and make a decision on all 4s the way that we're asking you to here. The other request that Mr. Davenport made at trial was for instructions that would allow the jury to for mitigating defense instructions. For instance, when a defendant in a murder case has drunk too much alcohol and he's facing extreme atrocity or cruelty liability, which was the only offense of conviction for Mr. Davenport, the court will instruct that the jury should consider whether that alcohol impaired the defendant's ability to make a decision in a normal manner. That's the sort of, and if they conclude that it did, then they're justified in bringing back a second-degree verdict instead of a first-degree. That was the type of instruction, one of the types of instructions that Mr. Davenport was looking for. Another type of instruction that he was looking for in mitigation was one that would be the equivalent of voluntary manslaughter, where your will is in effect cracked by the circumstances that you face, and you respond in a way that is not perfect, certainly, but the law recognizes the frailty of human nature under difficult, stressful circumstances by permitting a jury that's been properly instructed, if they find the evidence supports that verdict, to return a verdict of voluntary manslaughter instead of first-degree murder. Those instructions were also sought by Mr. Davenport at trial. Now, the second rationale, if you will, for the common law rule, I'd suggest doesn't hold any more water really than the first one, and that's the pragmatic rationale. The idea that the rule that obtains in the common law somehow deters this kind of conduct by people being aware of it and moderating or they're changing their behavior, their conduct in a way that will conform with the rule. And I think that sort of concern is dealt with by the instructions that you give in a duress case. You can
Well,
see,
what if there was no victim in this case, the way it played out, and three men were approaching your client with knives? What would his alternatives have been? To stand there and been stabbed to death, or to run? I take it
he would have been stabbed to death.
he would not. He would have chosen not to run.
Well, no, he would have attempted to run, but they would have caught him and stabbed him to death.
Well, why is that? I mean, are they better at running on railroad ties than he is?
There are three younger men, not intoxicated by heroin, with knives that they know how to use.
And he knew this at the time.
He'd been with them long enough to be very frightened of these people, yes. Yes, Your Honor. Now, the pragmatic concern that you see in the judge's memorandum ruling on this issue at trial is really addressed by the instruction that is given in every defense duress, where the court would instruct that duress is not available to a person who voluntarily enters into a criminal enterprise and is not available to a person who recklessly places himself in a situation where it's likely that such coercion may be applied. This fact-intensive inquiry belongs with the jury, and it's just wrong to foreclose it with an absolute bar preventing any person in the history of this state from taking his case of duress to the jury when it involves the intentional killing of an innocent person. I mean, imagine it's your child that has a gun to his head, and there's somebody like Luis Vasquez saying, if you don't kill this innocent person, I'm going to put a bullet through your child's head. And he shoots your first child, just so you'll know he's in it. He's serious. Your second child is next. What are you going to do? Is there never going to be a scenario in the history of this state that will warrant lowering this bar? Mr. Davenport's evidence warranted it, and I'd ask you to reverse the conviction, or, using your 33E authority, mitigate the case and find that he's guilty of manslaughter. Thank you, Your Honors.
Morning, Your Honors. May it please the Court. Zach Hillman on behalf of the Commonwealth. With me today is ADA Patrick Hagan, who was the trial prosecutor in this case. We're asking the Court to affirm the defendant's convictions and decline to exercise its authority pursuant to 33E.
Is there no point at which extreme duress should matter in a first-degree murder case? Is there no point at all? I mean, you heard the last sort of set of examples. Is there no point where the law can take that into account in some way?
There is not, Your Honor. Under the common law, no court in this country, either state or federal, has ever recognized that a person can be justified in taking an innocent life. There are states who have recognized that can be the case through their legislation, but no court has ever recognized as a matter of common law.
Well, I'm not talking about justified. I'm talking about perhaps lowering the degree, mitigating first-degree murder to some other form of murder or manslaughter.
No, Your Honor, I would suggest not, for a couple of reasons. First of all, duress doesn't fit into our scheme of manslaughter as we have it currently. And that's because manslaughter looks to, or in a case of manslaughter, sudden passion replaces the malice. In a case of duress, malice is never replaced. It's a defense that is built around an admission to all the elements, and there's no point in which a person's intent is mitigated. So duress doesn't fit into the current scheme of manslaughter. So that would require this court to enact some new area of homicide law. Now, I think that should...
What if they had said, let me just take a step away from murder for a minute. What if someone had gone up to Davenport and said, look, if you don't go in and steal money out of the cash register at this convenience store, I'm going to kill your child. Is duress, and he does it, is duress a defense? If he honestly believed and they had the means to kill the man's child?
In that case, under our law as it stands now, yes, but that doesn't involve the taking of an innocent life. And that's what we're talking about here. It is never justified to take an innocent life, and this court should hold that.
Again, justified is too strong a word as to what I'm suggesting, but it's never excused in whole or in part, never mitigated.
Never, Your Honor, never. And I would suggest that this court, again, shouldn't do that. If you look at cases where it is justified, where we recognize a justified killing under our law as it stands currently, self-defense, defense of another, even in a case of manslaughter where we have mitigation, the justification, the mitigation always comes from the victim. In this case, we don't have that. In the case of duress, we never have that. It is an innocent victim that has done nothing to the person who is going to kill them. I would suggest that this court should not make that the case. Consider, for example, a gang situation. Our state is plagued by gang violence like many others are. Consider a leader of a gang telling one of the foot soldiers, either you kill a rival gang member or we are going to kill you.
But being a gang member is specifically, at least under the modern penal code, one of those circumstances to which this wouldn't apply. Isn't that right?
Not necessarily. Not necessarily. The model penal code recognizes certainly that someone who places themselves recklessly in the situation may not be able to avail themselves. But I don't think just by being a member of a gang you put yourself in a reckless situation. But consider that the foot soldier goes and kills a rival gang member. Then in every case he would be able to plead duress, and in every case we may be looking at a mitigation to second degree or manslaughter. I think that should not be the case in this Commonwealth. Now, I would like to actually just set the scene of the facts in this case. The killing of the victim in this case took place about 3/4 of the way down the bridge. At the time that she was pulled down and the time that Davenport went up to her, Luis was 8 to 10 feet behind him, and then Ishmael and Parker were 10 yards behind Luis. The prosecutor, and this is on April 13th, in the April 13th volume of the transcript, page 256, beginning at line 4. The prosecutor asks, and this is Scott Davenport during cross-examination, prosecutor asks Davenport, well, at nighttime you know the bridge goes somewhere, right? Answer, well, of course it goes somewhere. Question, so the only thing standing between you and the other side were the 3 girls, is that right? Answer, yes. Question, and you could have easily run right by them and run down the tracks, couldn't you? Answer, I wouldn't say easily, but it could have happened. Question, could have? Answer, of course, yes. Now this is a case where...
That would be for the jury, and they might or might not accept that.
I disagree, actually, Your Honor. I would, by analogy, draw the court's attention to a self-defense case. Self-defense instruction certainly isn't appropriate where the defendant does not avail himself of all reasonable means of escape. I would point this court to Commonwealth versus Pike, a decision out of this court, as well as Commonwealth versus Berry, a decision out of this court.
But your theory really doesn't depend on the railroad tracks, does it? Because if this occurred in a room, a closed room, where there was no means of escape, you would still argue the same principle.
As far as duress not being a defense at all, absolutely, Your Honor. The defendant Davenport wasn't entitled to a duress defense in this case for both reasons. That one, duress is not a recognized defense at common law to intentional murder. And two, even on the facts of this case, even if it was a recognized offense, he had an available means of escape. Apart from running down the bridge, he could have jumped into the water. These are all reasonable avenues of escape that he could have taken. Instead, he went up to the victim, stabbed her with a 10-inch knife 7 times, and sliced her several more times. I would suggest this court should hold that as a matter of common law, duress is not a defense to intentional murder, and that even on the facts of this case, even if it were, Davenport was not entitled to the defense. I'd like to move to the severance issue.
Is there any evidence that he was crying or upset at the time?
There is. He did testify that he was upset, he was frightened, that he was crying. But again, that isn't enough to get the instruction. He has to avail himself of all reasonable means of escape, and he did not do that in this case.
Okay, severance.
Severance, Your Honor, yes. This case falls squarely within this court's opinions that hold that eyewitness testimony In a case where there's eyewitness testimony, severance is never required.
Is it eyewitness testimony, just eyewitness testimony, or is it independent eyewitness testimony?
I've searched through all the decisions that this court has discussed severance, and I have not found a single instance where this court has said it has to be independent eyewitness testimony.
Have you come across any instance in which the witnesses were former co-defendants?
There is a case, McAfee, out of this court, I believe. I could be mistaken, and I'll send a 16L letter just confirming that. But there is in that case, there were 5 eyewitnesses, or 5 defendants rather, and there are 3 eyewitnesses. And I think it's a little unclear from the court's decision whether a couple of those witnesses were in fact the co-defendants. But in this case, these women are not co-defendants; they are eyewitnesses.
Well, they were co-defendants.
They were, and certainly,
and until shortly before trial, they were.
Certainly, Your Honor. But that doesn't change the fact that they were eyewitnesses, and the fact that they were testifying pursuant to a cooperation agreement merely went to the weight that the jury was entitled to give their testimony. It is an instance of potential bias that is inherent in every single eyewitness. There is nothing that distinguishes these women from any other eyewitness in any of the other cases as a matter of bias goes. In addition to their eyewitness testimony, as far as Lewis goes, there was forensic evidence that put him at the scene on the bridge. That was the blood spatter evidence. One of our blood spatter experts testified that the spatter on Luis's shoes was such that he would have had to have been within a couple of feet of the bloodshed event.
I thought I read in one of the blue briefs that this was not an argument that the Commonwealth had made below.
That's absolutely not the case, Your Honor. While the prosecutor said that there was no DNA evidence from Luis that put him at the scene, there was forensic evidence, that is, the victim's blood and the spatter that was on Luis's shoes that put him at the scene, in addition to blood on Luis's sock that included the victim's DNA.
Wasn't there some question about where that came from, or whether that was really as a result of the mishandling of mixing together of?
There was argument as far as chain of custody goes, but as this court knows, that is an issue of weight for the jury. The way the evidence came out was one of the troopers picked up a plastic bag that contained all of Luis's clothing that he had when he was apprehended or when he was booked at the Cambridge jail. We also called the keeper of the records, who testified to the normal course and process of what happens when a prisoner comes in and the inventorying of the prisoner's clothing. The sheet, the inventory sheet, contains check marks for pants, jacket, shoes. It doesn't contain check marks for socks, and I think that's where the issue came up. Again, it was a matter of weight that that was for the jury, not an issue of admissibility. As far as Ishmael goes, Ishmael made statements also that that inculpated him. And those were the statements he made to Lauren Elaine and Anna White after he had been arrested. He wrote both of them letters, and he said, about you know what, don't say anything. And then to White, who was his girlfriend, he said, I'm sorry I got you into this. So the jury could have reasonably inferred that those statements were referring to the murder that took place on the bridge. Now, again, as far as the issue of severance goes, I would point out that had Luis and Ishmael been tried separately from Davenport, the Commonwealth's case would have been exactly the same. The evidence would have come in exactly the same. In Davenport's testimony was the very definition of cumulative testimony. His case added nothing to the Commonwealth's case. It didn't fill in any gaps. And it didn't force Ishmael and Lewis to defend their case any differently than they would have had they been tried separately. And I think those are the concerns that this court highlighted in Moran. None of those concerns were present in this case. Judge Brady properly denied the defendant's motions for severance. If there are no further questions on that issue, I'd move to the juror issue. And I think it's important for the single justice order issue here, referring to Justice Graney's order allowing the Commonwealth to exercise a peremptory challenge, to kind of highlight the procedure of how this came about. The first day of trial, the Commonwealth files a motion in limine to check the Corey records of jurors. Judge Brady says, I'm not going to do it, but Commonwealth, you can do it in your discretion. This is also coming on the heels of the very highly publicized Joseph Cousins trial, in which our office made it abundantly clear that we were going to be doing these type of Corey checks on jurors. Defense counsel were certainly on notice that we were going to be pursuing this line of action. On the first day, we impaneled 14 jurors. That night, we ran their records. The next morning, we gave them to defense counsel. That day, we picked the additional 4 jurors. That night, we ran their records. The next day we came in, we handed them to defense counsel. Now, while we said on the second day that we were content with the jury, I would suggest to this court that it would have been certainly apparent to defense counsel that we were content with this jury contingent upon not finding anything in the COI records that we thought was troubling.
Now, would you say that was the correct procedure to follow after the cases that have come down?
Actually, Your Honor, yes. This case was tried well before Cousins was decided, Hampton, and Carnes. But if you look at the prosecutor's line of action here, it foreshadows what this court says. We ran the records, we gave them to defense counsel, and when we found a juror that we thought had a troubling issue, we brought it to the court's attention, and we moved to exercise a peremptory. That's exactly what this court says the procedure should be.
Isn't there supposed to be something about doing it expressly contingent?
Well, that is in the Hampton decision, and that is a decision that came down after this case was tried.
So to that extent, it wouldn't be appropriate to do it as it was done?
Absolutely not, Your Honor. Again, I think it was apparent to all parties that we were content with this jury contingent upon the fact that we were going to run the records. Defense counsel were certainly on notice that that was our plan, especially considering the first day we ran their records and gave the records to defense counsel that morning. It would have been unreasonable for them to assume that we weren't going to do it with the remaining 4 jurors. Just briefly on the Bruton issue, Your Honors. Parker's statement that the others were going to kill him is not
it others or other members? It's
others.
Okay.
It's
In
others.
The blue brief says other members.
No, it's others, Your Honor. As far as my recollection goes, but I think it's others. And I think in any event, it doesn't matter because it doesn't expressly implicate, or it doesn't so obviously implicate Luis that it violates his confrontation rights. Again, we have to remember that Luis's defense was that I wasn't present at this point, and Parker's statement certainly doesn't put him at the scene. So there's no violation of the defendant's confrontation rights, and there's certainly no prejudice to Luis in this matter. If the court has no other questions, I would ask the court to affirm the defendant's convictions and decline to exercise its authority pursuant to Section 33E. This was a brutal, cold-blooded murder orchestrated by Luis and Ishmael. In fact, Luis participated in it when he went up and hit the defendant 3 times in the head with nunchucks. As for Davenport, he had an open avenue of escape. He declined to exercise that avenue. Instead, he plunged a 10-inch knife 7 times into this victim. Afterwards, he ran his hands through his hair and said, "What a rush." I think this is a case certainly where this court's exercise of authority under 33E is not warranted.
Thank you.
Thank you, Your Honors.